UCT's council announced yesterday that in principle, it will require lecturers and students to show adequate proof of vaccination next year. Discovery and Sanlam have also implemented mandatory vaccination policies. Nivaani Moodley, a lawyer at Weber Wentzel, joins me now. Thanks so much for your time on SABC News. So in light of vaccination being a choice, how does a mandatory vaccination policy at work in terms of our rights enshrined in the Constitution?
Thank you. That's a very interesting question. I'd just like to take a step back and talk about the occupational health and safety obligations that are placed on an employer before I actually answer your question. So in terms of the Occupational Health and Safety Act, there are several obligations that are placed on an employer. And some of these obligations are to ensure that the employer has a workplace that is safe and without risk to the health of its employees. So it is arguable that in light of these health and safety obligations, that mandatory vaccination may be implemented for employees, but it is important to bear in mind that mandatory vaccination may only be implemented after an employer has conducted its risk assessment. And the risk assessment must be in terms of the Health and Safety Directive that was published in June of this year. Now, an employee can argue that mandatory vaccination and excluding them from the workplace, for example, if they are not vaccinated, may be unfair discrimination, and that may be infringing on their constitutional rights. So, for example, the right to bodily integrity, the right to belief, opinion, and religion. However, we are of the view that it is arguable that the limitation of such rights, as I just mentioned in the Constitution, would be justifiable, taking into account the health and safety obligations that an employer has, as well as in light of public interest.
All right, so you've spoken about the rights of the employer and the employee and the things that they have to take into consideration. Talk to me about how the Protection of Personal Information Act fits into all of this.
Okay, so the Protection of Personal Information Act comes into play where an employer wants to know about its employees' vaccination status. So any sort of collection and retention of personal information must be in accordance with POPIA. And personal information such as medical health information is regarded as special personal information in terms of POPIA. There is no prohibition per se on requesting an employee's vaccination status. However, that must be done within the ambit of POPIA. So an employee must provide their consent and must be willing to share their vaccination status. And if an employee is not willing to share their vaccination status, I would suggest that be dealt with on a case-by-case basis. But if they refuse, then they should be regarded as not being vaccinated.
All right. I want to come back to one of the points that you made in the beginning of our discussion. In light of the fact that it's a global pandemic and there's devastating consequences that come from COVID-19, is there space for some rights to get curtailed?
Yes. Like I mentioned earlier, there would be a justifiable reason to limit those rights. And if we take a simple example of smoking. So our courts have held that everyone has a right to smoke, and preventing a person from smoking may infringe on their bodily integrity, for example. However, limiting those rights would be justifiable. And what that means is that a person who smokes can't just simply enter a restaurant or a cinema and smoke wherever they feel like it. There are designated smoking areas, and in that instance, it is regarded as a justifiable reason to limit a person's right to smoke. And similar principles would apply to mandatory vaccination, for example.
Okay. Nivaani Moodley from Weber Wentzel, thanks so much for your time and insight this afternoon on Point.